If you see our chat.
Yeah.
here on our criminal miscellaneous day for April 16th. Mr. Durrell.
Good morning, Your Honor.
Hold on just a second. Get organized here.
Yes, sir.
Okay.
May it please the court, Dustin Durrell, Your Honor. I'm standing in for Miss Larissa Dudley today. Miss Dudley's first client is a Ryan Patrick Asbury. He may be listed as no attorney on the docket.
No, it's got Ms. Dudley on it.
Okay. I don't believe he was transported today, Your Honor.
I don't have him listed as an inmate.
He was transported from Walton County.
He was supposed to have been, Your Honor, signed an order to transport him.
Okay.
So I believe he just arrived in the Okaloosa County Jail late last night, which is probably why he didn't make the transport list this morning.
Right.
If there's any way we can put him on the afternoon docket, I know Ms. Dudley is very adamant about getting the plea done today.
And, Your Honor, this was one that Miss Dudley and I had worked out a concurrent deal with what he's gonna get in Walton County, and this was to resolve the VOP before the Walton County case gets resolved, so he doesn't have a VOP hold after.
Can we let them know, to kind of, can we confirm through our website that he's there now? Can we do that? Through the jail website? Would it be?
I can ask. All you can find out.
But yeah, we can definitely do it this afternoon. Yeah, we'll do it this afternoon. We'll do it at 1:30.
1:30?
Do it with the arraignments.
He is in our jail, Your Honor.
What's that?
He is in our jail.
Okay, so can we do that? Can we transport him for
We'll be
the
in here at
1:30?
1:30 if you want me to.
Okay,
Thank you, Your Honor.
sure.
Next for Ms. Dudley is Daniel Jamal Askew. She indicates she just got discovery recently and would request a continuance.
This is Mr. Askew, Your Honor.
Okay. So it looks like this is the first time up, so we'll go ahead and make a denial,
Yes, Your Honor.
and then we'll come back, when we come back in a month or so, come back on May 21st.
521. Yes, Your Honor.
Okay.
Ms. Dudley just got discovery. She's requesting a continuance, so she can review that. We'll speak with you, okay? Okay. Your next court date is 521. Okay. Thank you.
Thank you.
Next, Your Honor, is a Mr. Dykes.
Okay.
Morning, I'm standing in for Larissa today. Your Honor, similar to Mr. Askew, Ms. Dudley indicates she just received discovery in this matter and would request a continuance.
Okay, I've got down, this is a miscellaneous, is this a violation of probation?
No, Your Honor, if you'll recall, Mr. Dykes was looking into a motion to withdraw his plea, and Miss Dudley entered an appearance for that possible purpose, so I sent her the discovery that the public defender had on the VOP, so she should have that now, and she's gonna make an evaluation whether.
I'm sorry, is this case of VOP, why don't we announce this 22 CF 29?
No,
I've
Your
got
Honor.
miscellaneous criminal here,
It is a
not a
mis-
VOP.
Yeah, it's
It's a new law charge?
It was a violation of probation, which he's already been sentenced for, and I think that the defendant possibly wants to do a motion and withdraw his plea, and Miss Dudley was gonna look into that for him. That's why it's labeled as
I'm
miscellaneous.
not following.
It sounds like this was set today for a potential motion to withdraw the plea to the violation of probation.
Correct.
Okay.
But we're requesting, Ms. Dudley's requesting
But
a
it is a
continuance.
VOP.
It was a
The underlying
VOP.
case is, is, I mean, is it change?
He's already been sentenced to the violations.
Sorry?
He says it's the DOC, and I was wanting to withdraw his plea.
So
So
what
has
is the
there been a
violation?
motion to withdraw the plea?
I'm unaware, Your Honor.
So
I
where are we
believe
at?
there was, but I think Ms. Dudley is requesting a continuance
do
to
what?
discuss the propriety of that with Mr. Dykes.
That's correct.
After she reviews the discovery.
That's correct.
Okay, so what do we need? Come back in a month?
Yes, Your Honor.
Okay, so we'll continue this matter till 5/21. Okay.
Thank you, Your Honor.
I think that's all you got.
Yes, sir. I'll see you back here at 1:30.
Yes, sir.
Thank you. Yes, sir.
So she's entered an appearance then?
Yes, he has.
Okay, so, Your Honor, I would ask, the
Yes.
PD will file appropriate paperwork to be relieved from representing Mr. Dykes.
Okay.
Since it sounds like private counsel has entered an appearance.
Well, I actually have her listed on today's
So
document.
we may have already filed it. We'll make sure. Thank you.
Thank you. Mr. Dean, you want to do, there's one,
Yes, I would like to do Mr. Adams.
Adams?
He's incompetent. If Frank Adams could approach with his brother, help him with the wheelchair, Your Honor.
Okay, hold on just a second, let me get that. Okay,
Frank Adams is before the court in 23 CF 2078. He's reporting as required. The court may recall there was a stipulated order for a signature bond. He is supposed to take all meds as prescribed. He's supposed to report the pretrial services, etc. I'm not exactly sure what the status of things are with that, but he is in court. The state is not willing to dismiss his case, and he is not competent. And his brother, to the extent his brother's able to communicate Frank Adams' wishes, says that Frank and certainly their respective mother, who is the alleged victim, they don't want him to agree to any, even a misdemeanor probation. So we're at a stalemate.
what's the state's position on where are we at?
Your Honor, so at this point,
So this is just a status today?
it's a status on competency, Your Honor, and we have not yet received word that he's been restored to competency, so I think we're going to have to continue his competency restoration training. That's where we're at.
Okay. And the state's wanting to continue to pursue the criminal charge, apparently, even though the victim and the entire family is opposed to it?
Yes, Your
I'm just
Honor, the state's proposed plea was reasonable, so yes, the state wants to proceed.
Your Honor, it was basically, as I understand it, I don't know if it's the first ever in the history of humanity, but wheelchair-to-wheelchair battery or something like that, where I don't think it's alleged. I may be wrong on those facts, but I don't think there's any allegation that he actually touched her body directly.
Well,
But-
Ms. Medina, I don't have anything
Right.
before the court to
Okay.
allow me to
Right.
to act on it.
Okay.
So,
Well, I would ask to continue this to maybe a couple appearances down the road so we can see where we are with Mr. Barnes, rather than have him come back in just a month,
sure.
if that's okay. Is there maybe a June or July date? If that's okay.
You tell me when. What month? You give me a month and I'll give you a date.
I would say July, Judge.
Okay. July 11th.
July 11 at 9 a.m.
Correct.
Okay, I'm gonna write that down for his brother. And y'all family can make an appointment, bring brother to the appointment, okay? Thank you.
Appreciate your assistance, sir.
Thank you, Your Honor.
Thank you.
Thank you, Your Honor, for
Sure.
allowing me to take him out of time.
Ms. Reed?
Hi, good morning, Judge.
Good morning.
I have one case on the court's docket under my name, Jonathan Richard Goodart, and that is case number 23CF2209. We were set today for change of plea for Mr. Goodart to enter into the pretrial intervention program. He has been referred and done his intake. I do have a signed written plea agreement. It's a plea to a lesser included possession of paraphernalia.
Okay.
Signed by all the parties. May I approach?
You may.
Great.
State?
That's correct.
Okay. Thank you very much.
I did check on the clerk's website this morning, and it did show the PTI was kind of flagged, highlighted as it did not match the charge, but I believe that this plea agreement will change that, and because it's a POP, possession of paraphernalia. Thank you.
Very good. Anything further we need to do on this case?
No, I don't believe so, Judge.
No, Judge.
Thank you, Ms. Reed.
Okay.
Appreciate your help.
Great, thanks, Judge. May I be excused?
You may.
Thank you. Y'all have a good day.
Mr. Swiatek.
Morning, Your Honor.
Good morning, Mr. White.
Len Swiatek for Abraham Evans in 22 CF 1454. Mr. Evans would like to announce ready for trial.
Okay, well, why are we having this case on a miscellaneous?
There was a few hiccups in the last time we were here in March, and the court said come back on this miscellaneous day.
No.
We got halfway through entering the plea, and the court wouldn't accept it and told us to redo it.
Your Honor, the state's happy to try this case on the June docket, but we had docket day yesterday. So we already have the cases that have been announced ready for trial. So I
Mr.
think this-
Swiatek, what,
Well, if it goes in July, no big deal. I mean, the case has been hanging around since 2022.
okay. So we'll continue to our next full cycle pretrial on 6/10. And at that time, you can announce ready for trial and we'll get it on that cycle.
All right. Can we go straight to docket day?
No.
Okay. What I try.
Sorry, we've got to walk through the process. I mean, who knows? You guys might, have a change of heart along the way, but anyway.
Thank you, Judge.
Okay,
Good day.
thank you. Ms. Graham?
Good morning, Your Honor.
Good morning, Ms. Graham.
Trisha Graham on behalf of Hannah Jagers. She's on 2 violation of probation cases, 23 CF 714 and 22 CF 3144.
What's the first one? I only have one of those.
Okay, I have 23 CF 714, and I believe the other one is 22 CF 3144.
So the 3144 is what's on my dock, but that's all right, we
Okay.
can do both.
Okay. Judge, I was just appointed.
Is the 23 CF 714 also a violation of probation?
Yes, I believe there's the 2 cases. I have to look, Your Honor, and see if one, maybe the 23 may be terminated because it's 11/29, it was the term. Not sure when she was placed on probation. I was just appointed this case on Friday, I believe it was, and found out it was in court today.
State, what's this, is that yours?
I apologize, Judge.
No, it's all right.
714 might be on your docket under number 16, because it was mine until recently.
That's right. Great, thank you.
Here we go. And Judge, we don't.
So is this the first time up for both of these violations of probation?
I believe she was set on the 11th, it looks like.
Has
I
there
don't
been
know.
a previous plea entered? Has there been a denial? Because usually when it comes up violation of probation, it's first time up.
Yeah, it says 4/11. I think there was a motion to withdraw then.
This is the first time? Okay, this is the first time up, so.
Okay, because I was
So-
here on the 11th. I didn't know. I was like, I got to appoint the next day, I think. She said she came on the 11th.
And, Rudy Harper, did he withdraw?
Yeah, I think maybe he withdrew, and so there was not a plea entered, so.
Okay, so
You
at
wish
this-
to enter a plea today?
Yes.
Oh, sorry, sir.
Okay.
We'll enter a denial as to the violations of probation for both cases at this time, Your Honor. And I haven't received anything. I spoke to the state to get information on what a possible resolution would be. If we can set it for an early court date, I believe the recommendation was community control. She is in custody and she's got a daughter, so we kind of want to address this as soon as the court is willing.
The next miscellaneous day is not until May 16th.
May 16th, okay.
And we've got some, you all can work with it. If we can get some things, the court will try to work within it. And we've got a couple weeks of jury trials. I mean, I'm kind of open if you got a resolution, certainly to get somebody out of jail.
Right.
Everybody appreciates that, including the inmate, but
Absolutely.
Certainly, the jail appreciates it too. We've got more than enough folks at the jail.
Absolutely. We don't have a resolution yet. I spoke with her just today.
So we'll continue it until 5/16, May 16th, but if you can get it something done before then, you know,
Yes.
you can get creative. I'm willing. We're gonna be here for trials, and it takes 5 minutes, you know, before we start the afternoon docket or something, we'll do it.
I appreciate that, Your
Okay,
Honor.
that's all
Thank
right.
you,
No,
State.
always.
Thank you. Thank you, Judge. May I be excused?
You may, thank you. Okay. Let me see here. Is Crystal Andis Kennedy here? Would you come forward? Just come to the podium.
Good morning, Your Honor.
Okay, good morning. Miss, what do you go by, Candace, Kennedy or Andis?
Candace.
Okay, Miss Andis, this is first time up on a violation of probation in case number 22 CF 2528. You do have the right to have an attorney. If you can't afford one will be appointed. So first order of business is trying to determine, do you wish to have an attorney appointed?
Not at this moment.
Okay. Why?
So this probation violation is for an FTA, and the FTA was what I have when I
Hold on a
got.
second. Does the state have something?
Yes, Your Honor,
Where-
I'm sorry.
where are we
I
at?
wasn't-
I'm just gonna let them, because they may
Okay.
jump in there. I'm seeing where you may be headed.
Your Honor, if you'll give me just a second, I'm looking at my notes on.
Okay?
Your Honor, yes, this is the case where I had some communication with Officer Becker. There was a violation that she just resolved for the DWLSR, and we already had added to her probation for that violation. I guess she had an unresolved failure to appear, right?
No, what happened was that, so when I got a probation violation for that, I got took into custody. When I bonded out, they
So
were.
you're relying on the defendant to tell you what the status of the case is, counsel?
No, Your Honor. So, Your Honor, at this time, the state's going to withdraw this violation of probation. No further action is necessary. We've already added to her probation, and the probation's not
Very
recommended.
good. Ma'am, this violation of probation is withdrawn by the state. Okay.
Thank you.
Thank you very much.
Yes, you have a good day.
Is probation reinstated or?
Hold on, ma'am.
Okay.
Yes, Your Honor. Probation has been reinstated. The state is withdrawing the violation, and she should continue to be on probation.
Okay. Yes, thank you very much. Okay,
Okay,
very
thank
good.
you.
Mr. Patel, who are you standing in for? I don't think you've got a case, do you?
Miss Oberleson.
Okay. Come on, let's see, let's call it out so they can pull her up. I know it's this is Hannah Gengiano. Or is she,
Yeah, I've got Boofer, or I can do whichever one.
Boofer has been already continued to May 1st on my docket. Would we check that? Would the clerk check that? 24 CF 624?
They were transported by.
That's all right. So-
No, I'm showing the change of plea was set for today.
Are you handling
Emails were a
Boofer?
little
Are you
different.
handling Boofer also?
Well, I was, but your office had indicated that the docket was too full to get her on, and so I didn't print off the necessary documents.
Notice of hearing was filed, setting it for today.
What's that?
A notice of hearing was filed, setting it for today.
Not to worry.
So I think what we did is we specially accommodated in order to do it on jury review, if my mistake, because we had so many this morning. So,
I think we're gonna have to move it, Judge, because I don't know.
I know you don't, there's nothing you can do. So if you want to, 4/18, April 18th, which is this Thursday.
So Judge, Ms. Oberleason's on military leave right now, and I'm not able to,
So you can't handle it because
I
you don't have the information.
that's right.
What do you want to do with Boofer, seeing that they, what is it currently set for, Madam Clerk?
Change of plea today and then also has the pre-trial for June.
For what?
June 10th.
Okay, so it's set for June 10th, but we'll try and get it in, you know, during, because we've got some jury trials, there may be some time for that.
Okay.
He is in the feed right now, Your Honor, if you want him out here for the conversation, or we can,
Should we talk, because yeah.
Is the state aware of what's going on? Who's
Yes,
handling
Your
it?
Honor. I'm just looking to see if Ms. Oberleason had actually sent it to me in email.
Judge.
That I could possibly print
I'm
it.
sorry, go ahead, Mr. Patel.
In speaking with Mr. Boofer, his family got contact from Ms. Oberleason stating that the plea, that it would be arranged for May 1 to enter the plea. I don't know what May 1 is on your calendar.
I don't either. Hold on, go ahead.
I have a copy of it signed that I can print out that Ms. Oberleason had sent over to me.
Yeah, I signed a copy of the plea. She came up and saw me last week.
If you'll just entertain us just 1 second. let me take a
I'll
quick
take
look.
your time. We're here, he's,
Yes.
thank you.
Of course. I just wanted to check before I had said anything.
Sure. No, I appreciate that.
So it looks like everything's tracked. And you went over this document
She came up and saw me.
and
Yeah, there's my signature.
that's your signature and that's, okay. Can we handle it, Judge?
Let's do it.
Judge, at this time, Jay Patel on behalf of Sarah Oberleason for Kenneth Boofer, 24 CF 632, 24 CF 628, 24 CF 624. I'll just announce the cases and counts. So 24 CF 632, burglary, occupied conveyance, count 2, petty theft. 24 CF 632, uttering false instrument, count 24 CF 624, unoccupied conveyance, fraudulent use of a credit card, and felony theft. At this time, he would be tendering a plea of no contest with the understanding that 24 CF 632, count 1, fines and court costs to collections, 24 months in the Department of Corrections with credit for time served. This should be concurrent and coterminous with his Bay County case, 21 CF 3376, count 2, 1129 OCJ, credit for time served, concurrent and coterminous with Bay County case, 21 CF 3376. 24 CF 628, count 1, fines and court costs to collections, 24 months DOC, credit for time served, concurrent and coterminous with Bay County Case 21 CF 3376, 24 CF 624, count 1 through 3, fines and court cost of collections, 24 months, Department of Corrections, concurrent and coterminous with Bay County Case 21 CF 3376. Restitution shall be reserved for 120 days. I can't approach with the written plea agreement, but I believe if you want to ask Mr. Boofer,
So has the state, is that the agreement?
That is the agreement, Your
And
Honor.
has the state signed it?
I have not signed it yet. I will
Okay.
print it out right now.
Can you print it from here?
Yes.
You can print it here?
I got a printer?
I don't have, I don't have
You
access.
gotta
to
walk
that.
somewhere to get it.
I was going to be
We can-
impressed.
If you had that one, that was a magic trick. No, just keep it for a second. Yeah, I mean, you can look at it. So, we can still enter the plea, but you're just gonna have to print it off here this morning and bring it to us so we can hand it to
Yes, Your Honor.
the clerk. So would you raise your right hand, Mr. Boofer? You swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, sir.
You just heard your attorney state, put your hand down. Heard your attorney state the terms of the plea agreement and I understand that you have signed that plea agreement and gone over it with your attorney?
Correct.
You had all your questions answered, legal questions answered about it?
Correct.
Importantly, this case is you're waiving some valuable legal rights. They're contained in the plea agreement. Waiving the right to go to a trial is the big one. Confront witnesses, everything. Do you understand have you had all your legal questions answered by your attorney?
Yes, sir.
And you believe that this is in your best interest to enter into this plea?
Yes, sir.
Very good. And nobody threatened or coerced you to get you to enter into the plea?
No, sir.
Okay. Based upon that, the court will accept your plea as stated by your attorney and is as contained in the plea agreement. And so the court will sentence you as stated in the plea agreement and as noted by your attorney in his rendition.
Judge,
So we just need to get that to me here sometime so the clerk can process it.
the score sheet, I'm told the score sheet reflects 33 points, so that shouldn't have any.
Okay, so it is not a downward departure. If you'll
Correct.
get me a score sheet as
That is
well, and
correct.
you're okay with that?
Yes, Judge.
Okay. So we'll get this thing resolved here today. Okay? Okay.
Now, will I have to come back on that first?
No,
Okay, so.
this is a resolution.
So I'm gonna be going back to DOC as soon as possible then?
I believe that's what the end result of this is.
Okay.
I'm not ordering that, but that's my understanding of, because there's another case over in Bay County, and that's where it was
You've already been
coterminous.
sentenced to DOC.
I'm actually in DOC right now.
Yeah.
I just came here for court
Right.
for this.
Yeah, so
case.
the court will get pushed through, then you go back.
Okay.
Okay.
All right, thank you.
You ready for Ms. Hannigan?
Yes, please.
So I'm gonna leave it up to you, make sure, and don't let me forget that agreement, Ms. Giordani.
Yes, I'm doing that right now, Your
That's all
Honor.
right, that's all right. I just want to make sure that as I get
This
kind of caught up in the middle of my
The
docket,
only thing I've
that
added
we don't
is
forget,
515
ladies, to make sure.
cost. You've gone over.
We get to the
this,
end of the day and
this is,
somehow don't get it done.
This is your signature, okay? And it looks like 5 months credit for time served concurrent and coterminous with these felony counts. Okay. Judge, at this time, Jay Patel, on behalf of Sarah Oberlease and for Margaret Hannigan, how do you say your last name? Kanano, 24 CF 640. At this time, Ms. Kanano changes her previous entered plea of not guilty and tenders a plea of no contest. The understanding is in 24 CF 640, count 1 is 5 months. Department of Corrections with credit, or 5 months Okaloosa County Jail with credit for time served, concurrent and coterminous with 22 CF 933, 22 CF 876, and 22 CF 231. Restitution is reserved for 120 days. The costs are to go to collections. The standard court cost and cost of prosecution is $515. I've indicated to Ms. Kanano that how it works is that once you sign the plea, then the jail will calculate, they'll see that her obligation is completed, and then she'll be returned back to the department. May I approach?
You may. Is this the agreement, is the state in agreement?
Yes, Your Honor, the state is in agreement.
And did I don't have on my docket these other cases. Did you get those cases? Are you,
Judge, I believe those cases, they're the ones that have been resolved where she's in DOC.
Yes, sir.
okay, so these are just coterminous to that.
Correct.
Okay,
Yeah.
so that's the only reference here. We're not dealing with these
No.
today.
No,
We're
sir.
only dealing with the 640.
Exactly, yeah, I'm,
Correct.
that time is
Mr.
right
Hill?
over my.
That's right, Judge.
Very
It's
good.
okay.
Okay, Ms. Kanano, would you raise your right hand? Do you swear or affirm that the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
Okay, so you heard the terms of the plea agreement. You're basically just trying to kind of conform all these different cases, it looks like. But this does, because this does have some legal ramifications, even though it may not result in you having any additional jail time, it does have legal ramifications. There's an adjudication of guilt. There's some other things. Just want to make sure you've had a chance to talk with your attorney. I know Mr. Patel's filling in, but Ms. Overlease or Mr. Patel, you've had a chance to ask questions about what this all means legally to you. Because you are waiving some rights to enter into this plea agreement. You're waiving the right to force to go to a trial, etc.
Yes, sir.
Have you had a chance to get all your legal questions answered?
I have.
Okay, and you're satisfied that this is in your best interest?
I am.
Okay, nobody threatened or coerced you to get you to enter into this plea?
No, sir.
Okay, very good. Based upon that, the court will accept this plea on 24 CF 640, and this is a single count, and the court is sentencing you to 5 months, incarcerative sentence of 5 months with credit for time served, concurrent and coterminous with 3 cases, 22 CF 933, 22 CF 878, and 22 CF 231. In addition, there'll be a reservation of 120 days for restitution, if those are put forth by the state, cost to collections, standard cost of prosecution in the amount of $515. Is that your understanding of all this?
It is, sir.
Okay. Any questions?
No, sir.
Okay. Score sheet?
We shouldn't need one, Judge, because it's just a county jail sentence.
Okay. Thank you very much.
No, so that's going to be the clerk. Yeah. Okay, all right, you're welcome.
Thank you.
Thank you, Judge. May I be excused?
You may. Thank you, Mr. Patel. Is Gary Ivy here? Would the state announce this case?
Yes, Judge. This is case number 4623 CF 001415.
Nope. Different case. Gary Ivy, 23 CF 1415. That's my docket, unless I'm mistaken.
I said 1415, Judge.
Okay.
I apologize.
Did we say the same thing?
I think we did. I think I gave the clerk number on accident, which starts with a 4. I apologize.
That's all right.
This is a VOP. The state is willing to offer 11 months Okaloosa County Jail if the defendant would like to resolve it today.
Okay. Mr. Ivy, generally speaking, when you're offered a jail sentence for a plea, you do have a right to have an attorney appointed.
Yes, sir.
So, first order of business, do you want to have an attorney appointed?
Yes, sir. If the state's offering 11 months, I have a chemical dependence problem is what my issue is.
I understand.
Yes, sir.
That's why I want to make sure and get you an attorney. So the court's going to appoint the public defender. What I'm going to do is I'm going to enter a denial on your behalf of this VOP. All that does is preserve your rights. So you have a chance to talk with your attorney, figure out your options, and then we'll come back in about a month and kind of take up the case.
Okay. In the month since I was arrested, I have done 3 things to try to help myself because of my...
Don't say anything at
Okay,
this point
all right.
about your case.
Okay.
What's the court date?
We'll come back on the 21st, May 21st.
Thanks, sir.
May
16th, Your Honor, for Mr. Ivy.
What did I say? May 16th? Yes.
May 21st.
May 21st. We're
Yes, Your
doing the
Honor.
16th and the 21st, we're kind of going back and forth. May 21st.
Thank you, Your Honor.
Is Robert Wells here? Robert Wells, State?
This is State versus Robert Wells, case number 2011CF00913. This is a violation of probation. I do not...
Was he properly served?
Let me check, Judge. It looks like the mail was returned as undeliverable.
Okay. Is that proper service? I think it is, isn't it?
I would think so. The state would request a KPS.
Court order a no bond KPS. Okay. We do have one inmate that doesn't have an attorney. Actually, 2. Let's go ahead and get those done.
Your Honor, may I approach with the plea agreement and this working for Mr. Boofer?
The earlier one?
Yes.
Yes, ma'am. Thank you. Thank you very much. So the first one, you want to?
Andrus?
Yeah. Andrus and then,
Griffin.
yes, sir. Perfect, thank you.
Okay.
This is Brett Andrus.
So would the state announce the case?
Your Honor, this is State versus Brett Cole Andrus, case number 23CF2765, here on violation of probation.
Okay, so Mr. Andrus, first order of business with this new charge, you do have the right to have an attorney. If you cannot afford one, one will be appointed. So do you wish to have an attorney appointed here today?
Yes.
Okay. The court will appoint the public defender. And what I'm going to do is I'm going to go ahead and enter a denial on your behalf. That will just preserve your rights, so you then can talk with your attorney and figure out where you're going. Okay? Okay. The court's going to enter a denial. We'll come back on May 16th at 9 a.m.
Anthony Griffin.
Good morning, Mr. Griffin. Would the state announce the case?
Oh, this is State versus Anthony Griffin, case number 2022 CF 001240 and 2022 CF 001257. These are 2 VOPs. The state's offer in this case is incarcerative.
Okay. So, Mr. Griffin, these are technically, well, not technically, they're new charges. So with these new charges, you do have the right to have an attorney.
Yes.
If you cannot afford one, one will be appointed. So my first order of business, do you wish me to appoint an attorney here today?
Please, sir.
Okay. So the court's going to appoint the public defender in both counts. I'm going to go ahead and enter a denial on your behalf.
Yes, sir.
Just so you can preserve your rights. That doesn't affect your rights at all by entering a denial. Give you a chance to meet up with your attorney
Yes.
And kind of look at your different options. So we're entering a denial. We'll come back we'll continue it until May 16th at 9 a.m. In the meantime, you'll be able to meet up with your attorney.
Yes, sir. Thank you.
Okay. Which one, is that yours, Mr. Gates?
Yes, Your Honor, Mr. Gates for Mr. Griffin.
Yeah.
Thank you, sir.
Yeah. Thanks.
Okay. I think, Harper. Okay. Ms. Farkas, you want to take some, Mr. Harper?
Sure.
Call to another.
I believe that Leroy Figures is in the audience. I can call.
I'm sorry?
Leroy Figures is in the audience. I
Okay.
can call his case.
Okay. Mr. Figures, please come forward. You just come up to the podium, sir.
Sorry. Your Honor, this is Leroy Figures. There are two dockets, 2023 CF 1120 and 2023 CF 1390. I've spoken with ASA Law School about this case. There was an amended VOP affidavit filed on the 10th. So we would like a continuance to discuss, given that there's some change in the situation.
That's correct, Judge.
We'll continue this matter until 5/21,
Thank you, Your Honor.
and that'll be at 9 o'clock. It'll be in the morning.
Your Honor, Anthony Klein's, he's not present. I've been in communication with. Oh, he's here. Oh, hi, you're here. Come on.
Hold on a second.
Got it. I didn't recognize him.
Who is this?
This is Anthony Klein's 2022 CF 1942.
Hold on just a second. Okay.
Your Honor, I've also been in contact with the state attorney in this case. If we could have one more continuance on this, I'm trying to work out something with the state. I don't think that there's an objection to a continuance. There's no objection.
We'll continue this matter until 5/16 at 9 a.m.
Thank you, Your Honor. Your Honor, I think that's all of my out-of-custody clients. I can do my in-custody clients.
See, Mr. Gates, do you want to do any of your out of custody?
Yes, Your Honor.
That's fine, too.
I've got one out of custody. Mr. Ivy, you're good to go. If I could call Teresa Gore, Your Honor, Ms. Gore is number 31 on the docket before the court.
Okay.
She's before the court 19 CF 862 and 22 CF 2928. We do have a plea agreement to be filed. If I may approach, Your Honor. It's a modification to the original worksheet provided.
Thank you. Would you announce the plea?
Yes, Your Honor. Ms. Gore will be admitting the violations before the court 19 CF 862, 22 CF 2928. She was previously adjudicated guilty. We're going to modify and reinstate her supervision of both cases. In 19 CF 862, Ms. Gore will be required to complete a substance abuse evaluation within 30 days, recommended treatment within 60 days, $100 cost of prosecution, $150 public defender fee, complete original requirements. In 22 CF 2928, Ms. Gore was required to do the saving grace program. That will be deleted as a requirement, and instead she'll be required to do an outpatient substance abuse evaluation within 30 days, recommended treatment within 60 days, standard court cost, public defender fee, complete original requirements.
State.
That's correct.
Ms. Gore, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
I do.
Okay, so you heard your attorney state the terms of your plea agreement. And I see those terms are in writing and you've signed it. So I just want to make sure, have you read this closely and gone over it with your attorney? Make sure you understand all the legal ins and outs of this? And you, yes?
Yes.
We're actually recording this.
Yes.
Okay. So just want to make sure that you have had all your legal questions answered. And you understand, importantly, you're waiving the right to go to a trial.
Yes.
And contest all this. You believe this is in your best interest to do this?
Yes.
And you've had all your legal questions answered?
Yes.
Okay. Based upon that, the court will accept your plea. The defendant was previously adjudicated guilty, and the court will modify and reinstate probation. On both cases, the defendant is going to be an additional requirement to complete a substance abuse evaluation within 30, and any recommended treatment within 60. There's some standard court costs and fees. Complete the original requirements except on 22 CF 2928. The saving grace requirement will be deleted and it will be substituted for the completion of the substance abuse evaluation and treatment. Question?
No.
Okay. Good luck.
Thank you, Your Honor. And that's all by out of custody, Your Honor.
Okay. Very good. So we'll go ahead and start bringing the inmates in. Ms. Farkas is your inmates. We'll do yours.
Ready to go.
This is James Carrier.
Your Honor, this is James Carrier, 2023 CF 492. We have the offer from the state attorney. However, I've spoken with Mr. Carrier this morning, and we're planning to schedule an evidentiary hearing at this point, so I've already let my assistant know, and we'll be scheduling that today.
Okay.
So I guess we continue.
So
with the
what
next-
we're going to just say, we're going to say, schedule an evidentiary TBD, which means you've got to contact my office in order to
Yes,
get
Your
in the
Honor.
afternoon. Okay?
Okay.
Very
Thank
good.
you so much.
Thank you.
Next is Chaplain.
Your Honor, this is Sean Chaplain, 2020 CF 292. This is the first time up on this VOP, so we'd like to enter a denial so I can come speak with Mr. Chaplain about the case.
Very good. The court will enter a denial on the defendant's behalf. We'll continue this matter until 5/16 at 9 a.m.
Gus Curley.
Thanks. Your Honor, this is Gus Curley, 2022 CF 1532, 2022 CF 1028, and 2022 CF 1542. I believe this is the first time I apologize, I take that back. The VOP was up in February and then a capias was issued. I would like a continuance.
I don't think we've entered a plea.
Oh, then I
According to
wasn't
my
totally
notes,
sure.
I may be wrong.
I think that's correct. So we'd like to enter a denial so I can speak with Mr. Curley about these cases.
Very good. We'll enter a denial, and we'll continue all three of these matters until May 21st at 9 a.m.
Shane Curry.
Your Honor,
Even
this-
though it's being unspoken, I'm assuming there's been communication between state and defense as far as any offers?
Yes, Your Honor, I have offers and
Okay.
I think all the cases.
If there hasn't been one relayed, jump in there, wave your hand, and I'll let you all, at least so we can exchange as much information as we can today.
Yes, sir.
I'm sorry,
Yes,
go
sir.
ahead, Ms.
No,
Farkas.
they've been very good about getting offers to us.
Okay.
Your Honor, sorry, this is Shane Curry, 2020 CF 2324. This is the first time the VOP is up. It was set to be arraigned last week with the storm, I believe. I am discussing the case with the state. If we could enter a denial and continue it to the next date.
We'll enter a denial. We'll come back. Mr. Shane Curry, correct?
Yeah, I'm sorry. I realized that we
He's already
actually,
entered a denial.
yes. And I continued it to today in the hopes that we would be able to reach a resolution, and we have not been able to.
Is there any way I can speak for just a second, Your Honor?
Talk to your attorney.
Advise my client not to say anything about the facts of his case, but
Okay.
if he would like to speak, then.
My children like need me home, man. Like I mean, like I'm not trying to be out to be in the streets or anything like that. Even if it was community control, if we could resolve today. Like I'm about to lose my house and everything, you know. Like, I mean, I would be willing to accept, you know, community control, anything, any stipulations you wanted to make.
Perhaps we can recall his case in a minute, and I can speak with the state attorney.
Okay, and why don't we do that?
Thank you.
Thank you very much. Thank you.
So right now, we're setting it to continue May 16th.
Yes, let's do that for now, and I'll speak with the state attorney.
Okay.
You'll come see me?
Yeah. I'll be right there. Your Honor, this is Leonard Dent, 2023 CF 2329 and 2023 CF 2208. We have an offer from the state attorney of a plea to the bench with a 12.1 month DOC cap. So I have that, and I'll have my client sign it, and then I believe that it's set off for sentencing, or would we do that today? Given that it's a cap at 12.1 months on the VOP.
I assume you're going to be making some arguments.
Yes, Your Honor.
So we need to set it for an afternoon. But it shouldn't take long, you know, it's a
Yes, Your Honor.
half hour, 45-minute
be a
hearing,
half-hour
but we do need to get it set.
Okay. Okay, so.
Is there going to be any PSI or anything like that?
Your Honor, the state wasn't going to request a PSI. I don't know if Ms. Marcus was.
I was not going to. If I can approach.
You may. Thank you. Would you go ahead and formally announce the agreement?
Yes, Your Honor. In Docket 2023 CF 2208, Mr. Dent was previously adjudicated guilty. Admit VOP, adjudicate guilt. Plea to the bench with a 12.1 DOC cap. Credit for all time served. Concurrent with 2023 2329 count 1. Revoke and terminate supervision. In 2023 CF 2329 count 1, that's the felony VOP, previously adjudicated guilty. Admit VOP, adjudicate guilt, plead to the bench with a 12.1 month cap. Credit for all time served, concurrent with 2208 count 1. Revoke and terminate supervision. In count 2, previously adjudicate guilt, admit VOP, credit for all time served, revoke and terminate supervision. I believe I copy and pasted an extra sentence there.
Your Honor, that's an accurate recitation of the state's offer.
The last sentence is duplicative.
Yes, it is. It's an error, Your Honor.
Scratch it. It's all right, at least you got it typed out nice.
Yes,
Appreciate
exactly.
that. Okay, Mr. Dent, would you raise your right hand, sir? Do you swear or affirm? I got to ask you a few questions. Do you swear or affirm the information you're about to provide this court is the truth, and nothing but the truth, so help you God?
Yes.
So as the state, this is the agreement?
Yes, Your Honor, that was the state's agreement.
So, Mr. Dent, you heard your attorney state the terms of your plea agreement, and I see those same terms are contained in the written plea agreement that you've signed. I just want to make sure have you read through this and had all your legal questions answered about this?
Yes.
Okay. And you understand that by entering into this, this is a plea to the bench, so you'll have an opportunity to argue, not you, but you and your attorney will have an opportunity to argue at the sentencing. But other than that, this will be a final resolution of your case other than the sentencing. Do you understand that?
Yeah.
You're waiving the right to go to a trial and to contest all these things. You believe this is in your best interest to enter into this plea agreement?
Yes.
And nobody coerced you or threatened you to get you to enter into this? No? Okay. Very good. Based upon that, the court will accept your plea. And on both of these cases, there's previous adjudication of guilt, and you're admitting the VOP. And both of these are pleas to the bench. As to there are three separate counts in two cases. Two of them are felonies. The felonies are both concurrent 12.1 caps with, of course, credit for time served. And the supervision will be revoked and terminated. So no more probation. Okay. And as to count 2 of 2329, that's the misdemeanor. That's credit for time served. That's done too. Okay. So all we're doing is coming back and arguing about the sentencing on the 2 other VOPs, and there'll be a cap of 12.1. That's the total. It's not cumulative. It's not 12.1 for each count. It's 12.1 total. They'll run together, basically, concurrent. Okay, is that your understanding?
Yeah.
Okay. So the court will accept this plea and sentence you at the appropriate time. So I think the sentencing is to be determined. You guys got to call my office, same thing in the afternoon. Put it on the docket. So I'm going to put a TBD. We'll do it as soon as we can in the next, month.
Just a point of clarification, Your Honor.
Sure.
Is probation revoked and terminated effective today, or will it be at the sentencing hearing?
At sentencing hearing.
At the jail.
Thank you.
I hadn't had that question, but it's a good question. I understand. Yeah. And is there a score sheet on this?
Your Honor, the score sheet will be presented at sentencing.
Okay.
But 12.1 would be within the guidelines.
Okay, very good.
I will have my assistant schedule that hearing.
Okay. Thank you.
Thank you. Dobbins?
Christine, leave this notes for this. Do you have?
Your Honor, I don't have the case number in front of me. I apologize. It's just
Okay,
William Dobbins.
2020 CF 2764.
Your Honor, this is William Dobbins. I've been speaking with State Attorney Basso, who is not here. Taylor Sharpless is sitting in for her. I requested medical records on behalf of Mr. Dobbins for evidentiary hearing mitigation purposes. I need to speak with Mr. Dobbins about the potential for setting an evidentiary hearing, but Ms. Basso and I are discussing a potential offer if we could have a continuance so that we could do that.
So we'll continue this until 5/16 at 9 a.m. If you have to go to a evidentiary, go ahead and schedule it up.
Yes, thank you.
And Ms. Basso, just for the record, Ms. Basso is expecting a continuance and let me know that
Sure.
she didn't.
No objection. Thank you.
Next is Ellis.
Your Honor, Mr. Ellis is here for a bond hearing. I'm not sure if you would like to do that now or. This is Michael Ellis, 2024 CF 0003.
Hold on just a second.
Okay, you may proceed.
Thank you, Your Honor. Like I said, this is Michael Ellis. He's here for a motion for a bond reduction. The current bond is $10,000 cash or professional, which is tantamount to remand for Mr. Ellis. He is unemployed due to a disability and receives Social Security disability as his sole income. He has been incarcerated since December 31st, 2023, as a result of being unable to pay the cash or professional bond that's currently in place. He resides with
What's the status of the underlying case?
The underlying case, Your Honor, we have discovery, body camera footage, photos, etc. When we appeared briefly yesterday, I let the court know that I think at this point we will be scheduling depositions. But we have most everything, I think, in the case. We've got all the discovery. So it is a third-degree felony. Mr. Ellis has not had a criminal history very recently. He does have a criminal history, but he hasn't had a failure to appear in over 20 years, except for once during the COVID-19 pandemic. And he turned himself in, as my client was just about to say, he turned himself in to the police, and he was released on an ROR because they knew that he was going to return himself to court. He has 2 children who live in the area. He's been living here his whole entire life. He lives with his fiance. They've been together for 20 years. So he has a stable address. He has family ties. He's never had a reason to leave, and he certainly doesn't plan to now. I would ask that you consider a signature bond. I'd of course ask for ROR, but I ask, if that's not possible, then a signature bond. I have every confidence that he will return himself to court.
Your Honor, the state would object to Mr. Ellis's bond being reduced, especially to a signature bond, Your Honor. $10,000 does seem high, but given defendant's criminal history, especially of the same or similar offenses, does lead the state to believe that.
I don't have that history in front of me.
Yes, Your Honor. So the state score sheet reflects that he has 3 prior grand thefts. He has 4 prior misdemeanor.
When?
I'm sorry, Your Honor, I don't have the dates, but I can look that up for the court. I know that it would have to have been in the last, he has to have had a criminal history in the last 10 years, or his prior record would not reflect anything on the score sheet. I show that he has 4 prior failure to appears, one of which was that 2020 incident that I did look up last night.
And what about the other ones?
Your Honor, I believe Ms. Farkas's recitation of the fact that prior to that they were in excess of 10 years ago.
Hold on.
I believe Ms. Farkas is correct about that, Your Honor. I don't think she's misleading the court about that.
I'm assuming she's misleading.
So, Your Honor, I'm showing that he had a felony petty theft as recently as January 2023, or it was resolved in January 2023 in Santa Rosa County.
Your Honor, I believe that was resolved as a misdemeanor.
I apologize. Huh? Sorry. So, Your Honor, he has multiple types of theft offenses on his prior record, Your Honor. So the state does believe that the $10,000 cashier professional is appropriate in this case and would ask the court to leave the bond as it has been issued.
Your Honor, if I may, as to the facts of this particular case, my client's alleged to have purchased a vehicle that didn't belong to the person who sold it. There's no violence alleged. There's no issue alleged with my client not responding to the police officers when they made contact with him and cooperating.
Say that again?
He's charged with purchasing a vehicle.
Other way around.
I'm sorry. He's charged with selling a vehicle that he believed he had bought legally, but the state is alleging that he did not purchase it legally. Hold on 1 second. My point being is that this is not a case in which, of course, there's financial injury alleged, but there's no physical injury alleged. My client has always cooperated with law enforcement. The fact that he has a criminal record but has never missed a court date but for one during the pandemic in the last 20 years, I think actually shows that he is able to return himself to court and handle his court dates responsibly. The basic fact of the matter is that, yes, this is a felony charge, but $10,000 might as well be $10 million for Mr. Ellis. There's no reasonable way that he would be able to post a cash or professional bond at that amount, which I believe goes against the purpose of the bond statute. The bond statute is meant to ensure that someone will return to court, ensure that they're not a danger to community, and something that is possible for them to pay. It is impossible for him to pay us.
So no, I could exactly agree with your characterization of the bond statute. Look, this kind of a case normally, Mr. Ellis, you know, the reason why I'm asking all these questions, this just wouldn't have a 10,000, except for one fact. I'm looking at the bond hearing. 26 prior misdemeanors, 13 prior felonies, 39 priors. That constitutes a danger to the community. I'm going to deny it. Thank you.
Watts.
Watts? Hold on a second, hold on.
Is yours gone yet? No, it goes in the other room. Marshall's apparently Docket, and he's asking me questions. I'm sorry. Where are we on Docket?
Go ahead.
Your Honor, this is Kyron Watts, 2023 CF 2065. He's also here for a bond hearing. I apologize, Your Honor. There are 6 charges here for Mr. Watts. The total bond is in excess of what Mr. Watts would be able to pay, to the point of also being tantamount to remand. Mr. Watts is 19 years old. He lives with his family. He's lived in Fort Walton Beach his entire life at the exact same address. He has, all his family is in the area. He has been employed for over 2 years at a company owned by his godmother. He had I believe one failure to appear. He was late to court, and that was resolved. Of course, Mr. Watts is not married, so he doesn't have those sorts of family ties here, but like I said, his godmother, his sister, his father, everybody lives here. The facts of the case are, of course, important given the level of severity of the charges, especially count 1. But looking at the arrest report, Mr. Watts is named only one time when the officers are listing the occupants in the car. He was the driver, but there is no allegation that he personally had his hands on any of the fentanyl that is charged here. Of course, I'm not trying to get into the legal aspects of possession, that's not my intent, but simply to say that he is listed only once when the occupants of the car being described. There were 5 individuals here. Depositions have occurred in the other cases. We touched on this briefly yesterday, and I'm waiting copies of those depositions, and we'll be scheduling depositions for Mr. Watts as well. But given his age and the fact that the arrest report does not bear out that the substances involved were in his direct possession, I ask that you consider a lower bond. My client has informed me that he could pay, his family could put together $10,000. They would be able to do that, his various family members here in the area. He would be able to come up with that amount for a bond. I'd ask that you consider lowering the cash or professional bond, despite the charges in front of you, because frankly, I think that Mr. Watts has a very good case, and I know that he will return to court. I think that everything I've put before you indicates he will. And I'd also like to, last thing, charges 3 and 4, which are child abuse without causing great bodily harm. Those charges are because 2 of the occupants of the car are juveniles. However, they're being charged as adults. So I guess they're both children and adults. Children when it is to charge my client with child abuse. So I'm not here to debate the counts. I just wanted to provide a little bit of information as to what those charges were. My client is not, the 2 of the occupants were juveniles. That's where those charges come from.
Your Honor, so the state does object to Mr. Watts's bond being lowered. Your Honor, he had a case in Walton County, that's 6623 CF 8182, which he's charged with possession of a controlled substance, which he was out on bond when this offense occurred. Your Honor, Mr. Watts fled and eluded after the troop.
He was out on bond?
He was out on bond when this offense occurred. Yes, Your Honor.
And what happened with that bond?
Your Honor, I am showing that a capias has been issued for Mr. Watts in regards to that. I believe since he's been here, he has not been transported to Walton County.
My point is, was that bond revoked in
I believe
Walton County?
I believe that they have done an order revoking bond. It just has not been served because he's been here, Your Honor. Your Honor, the trooper attempted to stop the car Mr. Watts was driving. Mr. Watts continued at a high rate of speed down Highway 85, while the front seat passenger threw a gun and a magazine and counterfeit alprazolam pills that tested positive for fentanyl out the window. Your Honor, there was also confirmed fentanyl in the back hatch of this car. This car was like a crossover SUV type thing, laying in the back of the car. And Your Honor, I think it's important to note that when we took depositions, the trooper indicated that the tent was too dark to tell if he was not able to tell if there was movement within the car while he was chasing it because the tent was too dark on the windows, Your Honor. So I do believe that the fentanyl, the guns and the fake alprazolam being thrown out the window, in addition to fentanyl being found in the car, in addition to, I believe Mr. Watts also had cash on him. I need to check that fact, Your Honor. But several of the individuals in this car did have a large amount of cash on them, as well as one of them had a scale with residue which tested positive for fentanyl on them, Your Honor. I do believe that all of these individuals were involved in fentanyl trafficking and drug dealing, Your Honor, but I think the most telling thing is that he was fleeing and eluding from the police and involved in trafficking, possibly while he was out on bond for possession of a controlled substance, Your Honor. So the state believes that the bond as set is appropriate and the court should not reduce it.
Your Honor, if I may. Respectfully, most everything that ASA Sharpless just said related to the drugs that were found were about the co-defendants, not about my client. My client, I would say the strongest case that they have is the fleeing and eluding. That's certainly the strongest charge here. The car itself was not in my client's name. It was rented by another individual from a company, I believe it's called Toro. So it's kind of like Airbnb for cars. So the tint of the windows is not, first of all, it's not charged here, of course, and also the car is not in my client's name. My client was found with $455 in his pocket, nowhere near the amount found in the co-defendant's possession. I'm certainly not minimizing the severity of the charges here, but I'm asking that you consider a bond that my client would be able to make and return himself to court. He would have returned himself to court in the other case, but for he's been here at the jail.
In the other case, the Walton County case?
Yes, Your Honor.
He would have been returned in the Walton County case in order for them to revoke his bond because he picked up a new charge.
Yes, Your Honor, but as State Attorney Sharpless said, that warrant hadn't been served yet. I'm not sure when it was issued. Like I said, I'm not trying to argue that he...
Well, the very fact that he picked up new charges while he's out on a possession charge, that pretty much negates much of your argument as far as safety to the community. And to add to that, you know, we're dealing with we're dealing with the scourge of fentanyl, and I've said it many times from my position here, and I'll continue to say it. Special consideration, that's a safety issue. You're a young man, it's a shame that you're getting caught up in this. I just presided over a sentencing of a guy who you're fleeing and eluding at 100 miles an hour. I had a sentence where a guy crossed over because he fell asleep because he was coming from work and direct head killed somebody, spending much of the rest of his life in jail. You're darn lucky that didn't happen to you. The court's denying your request for lower bond.
Your Honor, I apologize. This is Kesha Carter, 2022 CF 2723.
Hold on just a second. I'm sorry. Okay, go ahead.
Like I said, this is Kesha Carter, 2022 CF 2723. The state and the defense have worked out an agreement. I've spoken with Ms. Carter about this at the jail. I'm just going to have her sign it now.
Okay.
If I may approach, Your Honor.
Would you please announce the agreement?
Yes, Your Honor. In docket 2022 CF 2723, this is the VOP charge. There was a previous adjudication of guilt, admit VOP, adjudicate guilty, 12.1 DOC, credit for all time served, revoke and terminate supervision, $100 cost of prosecution, $150 public defender fee, should be given 180 days to pay upon release. In 2024's MM 0117, which is not before you, but is on the docket, the misdemeanor docket that she has tomorrow. Adjudication of guilt on all 3 counts, credit for all time served.
Your Honor, that's the state's agreement.
Very good. Ms. Carter, would you raise your right hand, please?
Yes,
Do
sir.
you swear or affirm the information you're about to provide this court is the truth and nothing but the truth, so help you God?
Yes, sir.
So you heard your attorney state the terms of the plea agreement, and I see those same terms are contained in the written plea agreement that you've signed. Have you had a chance to go over this plea agreement in detail? You
Yes,
read
sir.
it?
Yes, sir, I did.
And have you gone over it and made sure you had all your legal questions answered about the plea agreement? Because it has some significant impact on you. Obviously, there's some DOC time, but also you're waiving some valuable legal rights, the right to contest these, force the state to prove their case beyond every reasonable doubt. You're waiving that in order to have a final resolution here today. Is that what you want to do here today, and do you believe that that's in your best interest?
Yes, sir.
And you're entering this freely and voluntarily?
Yes, I am.
Nobody threatened or coerced you to get you to enter into the plea?
No, sir.
Very good. Based upon that, the court will accept the plea agreement, and in 22 CF 2723, there was a previous adjudication of guilt, and with this admission of VOP, the court will sentence the defendant to 12.1 months in the Department of Corrections. You will get credit for all time served. Supervision will be revoked and terminated, so no more probation on this. And you'll have the standard cost of prosecution and public defender's fee. You'll have 180 days to pay. I'm going to ask you to insert in this 180 days to pay after she gets out of DOC.
Yes,
So-
thank you.
Wait, so let me finish that. I'm sorry.
It's not filed information in the misdemeanor case, so she can't be sentenced to
Your Honor, can we do this? Can we bring her, if it's possible, if the court's good, that can we bring her back this afternoon and I'll attempt to get an information filed in that misdemeanor case?
Thank you.
Yes.
I mean, not that she doesn't have 12-1 credit, but if we can get it done. Right. Yeah.
Okay, so we'll come back in this afternoon.
Okay, thank you, Your Honor.
Next, Holly Snowden.
This is starting with Mr. Harper's.
Ms. Snowden is my client.
Okay. Oh, this is Holly.
Your Honor, this is Holly Snowden, 2019 CF 1894. This is a VOP. The state and the defense have reached an agreement in this case, and I'm having my client sign it now. We have gone up. Oh, I didn't put this one back. Yep. Thank you.
Do you have the score sheet?
Yes. So I'm having my client sign it now.
Can't see that.
Yes.
Oh, you signed it in the attorney's file.
It's okay. You can sign up there and I'll cross it out. It's okay. Yeah.
But their citations in this case.
An updated score sheet is going to be forwarded to you by the state.
On this case?
Yes, but this is not a downward departure.
Thank you.
She does not score.
you announce the agreement, please?
Yes, Your Honor. In just the one case before you, Ms. Snowden was previously adjudicated guilty on all 3 counts. She'll be admitting the VOP on all counts, credit for all time served, revoke and terminate supervision, $100 cost of prosecution, $150 public defender fee. And I need to put that she has time to pay those.
State?
That's correct, Judge.
So basically, we're just revoking and terminating and adding some costs?
That's correct, Judge. With credit for time served.
Sure, sure. Ms. Snowden, would you raise your right hand? Do you swear or affirm the information you're about to provide this court is the truth, nothing but the truth, so help you God?
Yes, Your Honor.
So you heard the terms of the plea agreement, pretty straightforward. You'll get credit for time served. You'll have to pay some additional fees and costs, and that'll be the sum total, the credit for time served. So, but I just want to make sure you've had a chance to talk with your attorney, make sure you had all your legal questions answered, because this does have some impact on your record and all that stuff.
I'm very much aware of that, Your Honor.
You believe, obviously, this is in your best interest. I'm not even going to ask you that, it's so obvious. Based upon that, the court, based upon your testimony, the court will accept your plea. You were previously adjudicated guilty on all counts. All of the VOPs will be admitted, and you'll receive credit for all time served on all 3. That's your sentence, and supervision will be revoked and terminated with some additional fees and costs. We want to give the defendant some time, give you 180 days to pay these before it goes to collections, and try and pay them before then so they don't go after your driver's license.
Yes, I have a good driver's license.
Anything else? Good luck.
Thank you. Appreciate your time, pal.
I was hoping I could slide in with my 3 out of custody.
Sure. Why don't we do that? We'll do that, and then let's take a short morning break.
Thank you, that would help.
And then we'll come back. But we'll do the 3 out of, so.
Thank you, Your Honor. Can I get Sabrina S. Bethune? And then after Ms. Bethune will be Brent Buffer. I'm sorry, Judge, can I give you the docket number? I don't have it with me, but
Bethune?
Bethune, yes.
I've got it. It's 23 CF 2019.
Yes, Your Honor. Steve Medina with Ms. Bethune. Your Honor, she is, has completed her community service hours. That proof was sent to the state. She's making progress on the payment of the monetary obligation. She works at Chick-fil-A. She thinks she can pay $200 off a month, something like that. It looks like she probably has maybe $1,500 approximately, something like that to do. But she is asking, would there be any way that's only monetary obligations? She didn't want to have to do community control for monetary obligations that we think were beyond her control. Would it be possible, would the state consider administrative non-reporting probation, and then we can get her off the VOP docket and just have her do administrative, since it's basically just payment of monetary obligations? Would the state consider administrative?
I would have to look at it.
Okay. Can we continue this for one cycle, then we'll work on or a month, and then we'll
Sure.
work on the
We'll continue
possibility
this
of
until
administrative.
May 16th, 9 a.m.
I know that's not something we typically do in felony court, but it would be routine in misdemeanor court, so hopefully we can work something out for her.
Okay.
When did the court say? I apologize.
May 16th.
May 16th. Okay. Okay. Thank you, Your Honor. Okay. We'll go ahead for you. Thank you, Your Honor.
Thank you.
Next, after Mr. Buckner, will be Mr. Porterfield. Brent J. Buckner before the court in 23 CF 491 and 23 CT 1165, which was originally pled out in a global plea and is under the jurisdiction of the felony court. That's 23 CT 1165. Your Honor, he's provided me some paperwork on his completion of Florida Springs treatment, but I need this actual certificate. He's starting his DUI school, which he had financial problems, especially while he was getting residential treatment. So he's got a new job, and so if we could continue this, would the state have any objection to a 2-month continuance to see what progress he can make?
No objection.
Would something like June or July be okay, Judge?
Fine. How about June 18th?
Thank you. Okay? You can take a leave. Thank you, Your Honor.
Thank you. What's your last one?
The last one is Porterfield, Charles A. Porterfield. And on this one, it may be that we could put him aside to the afternoon. He came all the way from North Carolina. This is Charles A. Porterfield before the court in 17 CF 1273. Basically, he was alleged to have violated the Florida probation on Escambia County charges that he represents to me. He did 3 years DOC, Florida DOC on. And it may be that we can work out some sort of a credit for time served. He's already a convicted felon.
You want to come back this afternoon?
So if we work, yes, we may. If the state may have a chance to check into Porterfield. I'm not sure who is handling Porterfield.
I'll look into that.
Can we set him aside to the afternoon? It's better for him to resolve it today
Sure.
if he can than have to come all the way back. So just come back at 1:30. Is that okay, Judge?
1:30 is fine.
Okay. Thank you.
Okay, so that's your 3. So
Yes,
good
yeah.
time to take a break.
Yeah, just, can I put one other thing before, it was an odd
Sure.
I had Frank Adams, 23 CF 2078. He's the incompetent gentleman who was in the wheelchair.
Yes.
Just needed to clarify a couple things on the record. Number one is that I kind of factually stated that it was maybe wheelchair to wheelchair contact, but I had the facts wrong on that. I think he was alleged to have shaken his mother's wheelchair, and I understand the state's position because the mom wants to make sure he's on medication. The second thing is that it may be that we don't have an incompetency finding. He was stipulated ROR, but he's been before the court. The court's considered his status, so I think we could probably just have a stipulated order finding that he is incompetent because he's appeared before the court, and that'll set a foundation to get John.
He's competent or incompetent?
Incompetent.
Okay.
Because I don't think that the court ever officially declared him incompetent. I'll check back, but if that is a flaw, then I want to correct it so we can have a basis for working with Mr. Barnes.
I would agree.
Yeah, and I wasn't trying to make the state misstate it for Ms. Sharpless purposes. I know the state has concerns based on the victim input. Thank you.
We don't ever want to misstate any of the facts on purpose.
Thank you.
Okay, so we need to do one?
Very, very briefly, Your Honor. This is a client who wasn't transported, and so I just wanted to make a record. Jamal Ferguson.
Okay, hold on.
I apologize, Your Honor.
Okay. He was not transported?
Other institutions.
Oh.
Yes, Your Honor. He's in the Santa Rosa County Jail.
Okay.
And he has a deposition this afternoon, so we did not request that he be transported.
So this was an evidentiary, which means it's already been previously pled?
Yes.
So we'll continue it?
Yes.
How long? A month? Continue it a month?
Can we approach, Your Honor?
Sure.
Yeah.
Check out the soaps, bath bombs, and other bath and body products, all made by hand with natural ingredients at Hub City Soapery. Visit us at 1092 North Verdon Boulevard in Crestview or shop online at hubcitysoapery.com. Hub City Soapery.
This is Tiffany Woodham, State Farm's newest agent in Crestview. I'd like to personally invite you to stop by my office for a no-cost policy review. Let me help you start saving today. Call in, walk in, or click in at yourcrestviewagent.com.
Alabama, or is that your last case?
I have Marcus Snowden with Mr. Harper.
You want to deal with that so you can get
That
out
would
of
be
here?
wonderful. I have to be in the same place Ms. Farkas
Mr.
needs to be.
Harper, you want to, you want to do that? See, once you lost your slot, Ms. Farkas, man, she just took over the docket this morning. Hold on a second.
Yes. Just one. Marcus, probably. Yeah.
Marcus Snowden, Judge.
Judge Rudy Harper on behalf of Marcus Snowden before the court on 21 CF 2286. Without rehashing the substance of my motion, basically, Mr. Snowden had a bond. That bond was revoked in April of 2022 due to an allegation, actually due to a charge in Alabama, misdemeanor, for which he pled and was sentenced. Subsequently, his bond was revoked here. He's been in custody here.
What was his bond here previously?
I think it was 50 cash professional, 50,000 cash professional. Since that time, Judge, we've done everything. Discovery is complete in this matter. The court may recall that we recently attempted to do the deposition of a confidential informant that was in federal custody. We went up to Alabama, did that deposition. That individual declined to participate in the deposition. In fact, I bluntly asked him at the deposition the question that he would only provide testimony if he received payment for it, a benefit. And he answered that that was his position, that he didn't receive a benefit, therefore he's not testifying. In the present case, all depots are complete. There is no evidence tying my client to this incident. There's no nexus. No witnesses, there's no DNA evidence, there's no fingerprint evidence, there's no audio, video, surveillance, nothing tying my client to this incident. The only thing is this confidential informant who pointed the finger at my client and then in a sense subsequently declined to participate further. That confidential informant actually informed on a number of people. There's a whole litany of people that he testified against in the hopes of bettering his position in his federal case. In that there is no nexus between my client and the allegations in this case. This is a cold case. There's no physical evidence. We've done like 50 plus depositions. There's nothing tying my client to this case. I am asking, in lieu of just a mere reinstatement of his bond, a conversion of his previously entered bond to a signature bond. He's been away from his family, away from his children, away from his wife for an excess of, at this point, 2 years for a case for which there is no evidence. I'm not certain at this point that the case would survive a corpus argument for a motion to dismiss. So, in light of that, Judge, I would ask for a signature bond in Mr. Snowden's case.
Your Honor, the confidential informant did state that he wanted some sort of benefit to testify, and that's what the state's working on right now, is working with the U.S. Attorney because the terms of his plea agreement do require that he testify truthfully in all matters in which he was called. And the state is in the process of trying to get an appointment with his defense attorney In federal court, they call it a Rule 35, so that he can, quite frankly, get some benefit to his testimony. He wasn't given benefit for this particular incident. However, the confidential informant explained the crime in this case that involves Mr. Snowden with great detail and specificity, and claimed that Mr. Snowden did in fact confess to him the details of this crime. There is DNA evidence placing Mr. Snowden around the crime scene area, so there isn't a complete lack of nexus. I would say that this witness is particularly critical, but the state is working on procuring that witness's testimony, to be quite frank. There is some other testimony from co-defendants that talk about arranging this offense, and Mr. Snowden was not from around the area, so there'd be no reason for his DNA to be at or around this area. So it's a bit more complicated than Mr. Harper does say. With that being said, he has been in custody for 2 years. It was a misdemeanor domestic violence, so the state, while clarifying those facts, does leave it in the court's discretion.
Your Honor, if I may briefly respond. Judge, with respect to the DNA in question, that DNA was found blocks away on a hat. There's actually no nexus between that hat and the allegations of the incident itself, other than the fact that a hat was found, happened to have Mr. Snowden's DNA. There's no allegations that the person wearing that hat committed the crime, nothing to that effect. And again, Your Honor, we would ask at this point, in that discovery is complete, I completely understand the state's position in that they're recently assigned this case. I think she just filed a notice of appearance. And I understand. This case was continued over multiple co-defendants' attorneys' objection. We're ready to proceed forward to trial. I understand the reasoning behind that, Judge. But the fact of the matter is that my client's stuck in jail waiting for a case to be resolved that evidence in this case is sparse at best from our perspective. So I would ask the courts to permit Mr. Snowden to be released in the month and a half that he has remaining before we set this for trial.
Well, based upon the fact that the revocation of the bond was based on a misdemeanor and that has been resolved, the court will reinstate his bond. I'm not going to reduce it. I'm going to just reinstate it at 50. Apparently he was able to get out on that. So the court will reinstate the bond.
Thank you,
Anything
Judge.
further?
I think that this matter has already been continued at 6/12.
Okay, very good. Thank you.
Okay, thanks. Yes, sir.
Okay, so we will take a break now.
And, Your Honor, that completes my business with court. May I be excused?
Thank you.
Thank you, sir.
All right.